The Supreme Court's presidential immunity ruling is not over. It is just beginning. In July 2024, the Supreme Court issued one of the most consequential decisions in modern American history. They ruled that former presidents enjoy broad immunity from criminal prosecution for official acts. The decision sent shockwaves through the legal world, but here is what most coverage misses. The Supreme Court did not end the case against Donald Trump. They sent it back to the lower court with instructions, and those instructions created a complex legal process with multiple deadlines, multiple determinations, and massive implications for the future of presidential accountability. Right now, Judge Tanya Chutkan is working through a methodical process to determine which of Trump's alleged actions were official acts entitled to immunity and which were private acts that can be prosecuted. The deadlines in this process matter enormously. Today, I am going to break down exactly what the Supreme Court ruled, what the immunity framework actually means, how the lower court process works, and what deadlines you should be watching. This is not speculation. This is constitutional law, procedural requirements, and documented court filings. If you want to understand the most important legal battle of our time, stay with me. Subscribe to this channel for analysis that explains the substance, not just the headlines. Let's get into it. Before we can understand the deadlines, we need to understand what the Supreme Court actually decided, because the ruling was more nuanced and more consequential than most coverage suggested. The case was Trump v. United States. The question before the court was whether a former president can be criminally prosecuted for conduct that occurred during his presidency. The court's answer, delivered in a 6-3 decision written by Chief Justice John Roberts, established a three-tiered framework for presidential immunity. The court held that when a president exercises powers granted exclusively to the presidency by the Constitution, he has absolute immunity from criminal prosecution. No exceptions. No balancing test, complete protection. What falls into this category? The court specifically mentioned the pardon power, the power to recognize foreign nations, the power to command the military, and the power to veto legislation. These are powers that only the president possesses, and the court held that prosecuting a president for exercising these powers would unconstitutionally intrude on executive authority. For other official acts, those taken in the president's official capacity but not involving core constitutional powers, the court established presumptive immunity. This means the president is immune unless prosecutors can demonstrate that prosecution would not impermissibly intrude on executive branch authority. This is a heavy burden. The court was clear that this presumption is difficult to overcome. Prosecutors must show that their specific prosecution of a specific act would not threaten the independence or functioning of the executive branch. For purely private conduct, unofficial acts that have nothing to do with presidential duties, there is no immunity. A president who commits a crime in his personal capacity, unrelated to his official responsibilities, can be prosecuted like any other citizen. The court did not determine which of Trump's alleged actions in the January 6th indictment fell into which category. That determination was left to the district court, Judge Tanya Chutkan, and this is where the process gets complicated. The court did not simply say figure out what is official and what is not. They added constraints that significantly favor the defense. First, prosecutors cannot use evidence of official acts to prove crimes involving unofficial acts, even if an unofficial act is prosecutable. The government cannot point to official communications, official meetings, or official decisions as evidence of criminal intent. Second, the court specifically addressed several categories of conduct alleged in the indictment regarding Trump's conversations with the Department of Justice about election fraud claims. The court said these were official acts involving the president's supervisory authority over the executive branch. They appear to receive absolute immunity regarding Trump's pressure on Vice President Mike Pence to reject electoral votes. The court said this requires further analysis. The president does have authority to discuss matters with the vice president, but the vice president's role in counting electoral votes is arguably a legislative function, not an executive one. Regarding Trump's interactions with state officials, private lawyers, and the January 6th rally, the court suggested these might be unofficial acts, but it left the determination to the lower court. This framework created the legal process now underway, a process with specific deadlines and massive stakes. Judge Tanya Chutkan now faces an extraordinarily complex task. She must apply the Supreme Court's framework to the specific factual allegations in the indictment and determine, act by act, what is official and what is not. Let me walk you through how this process works. Both sides, special counsel Jack Smith's team and Trump's defense lawyers, submit written arguments about which acts are official and which are unofficial. They analyze the Supreme Court's framework, apply it to the facts, and argue for their interpretation. This briefing process has specific deadlines. The court sets schedules for initial briefs, response briefs, and reply briefs. Missing these deadlines can have serious consequences because the Supreme Court ruled that evidence of official acts cannot be used to prove unofficial conduct. The district court may need to conduct hearings to determine what evidence is admissible. This is unprecedented territory. Courts have not previously had to sort presidential conduct into immunity categories and then determine how those categories affect evidence admissibility. Judge Chutkan is building the airplane while flying it. After briefing and any necessary hearings, Judge Chutkan will issue a ruling determining which acts are official and which are unofficial. This ruling will effectively narrow the indictment, potentially eliminating some charges entirely. Whatever Judge Chutkan decides, the losing side will almost certainly appeal the D.C. Circuit. Court of Appeals will review her determinations, and the Supreme Court may weigh in again. This appellate process takes time, months at minimum, potentially longer if the Supreme Court grants certiorari again. Here is the uncomfortable truth that the legal process forces us to confront. The immunity determination process will take months. Appeals will take additional months. Even if prosecutors ultimately retain viable charges, trial would not occur until well after the 2024 election. And if Trump wins the election, the calculus changes entirely. A sitting president has never been indicted. Department of Justice policy, established in Office of Legal Counsel memos, holds that a sitting president cannot be prosecuted. Trump's attorney general could simply dismiss the case. The immunity ruling did not just establish legal principles. It established a timeline, and that timeline may matter more than the legal principles themselves. Let me step back and explain why this immunity ruling matters beyond the Trump case itself. The Supreme Court did not just rule on one defendant's motion. They established constitutional law that will govern presidential accountability for generations. For 235 years, the assumption in American law was that no one is above the law. Presidents could be impeached, removed, and then prosecuted. That was the mechanism for accountability. The Supreme Court just changed that assumption. They created a category of conduct, official acts, that is now largely immune from criminal prosecution regardless of how corrupt or criminal the motivation. Let me give you a hypothetical. To illustrate why legal scholars are alarmed, imagine a president who orders the FBI director to investigate his political opponents on fabricated charges. Under the old understanding, this would be a clear abuse of power, potentially criminal. Under the new framework, giving instructions to the FBI director is an official act. It involves the president's supervisory authority over the executive branch. The president would have absolute or presumptive immunity from prosecution for this conduct. But wait, you might say, surely ordering investigations for corrupt purposes is different from ordering legitimate investigations. The motivation should matter. Here is the problem. The Supreme Court specifically held that courts cannot inquire into presidential motivation when the act itself is official. They wrote that examining motivation would chill presidential decision-making and allow prosecutors to second-guess legitimate policy choices. This means that the official nature of an act, not its corrupt purpose, determines immunity. Justice Sotomayor's dissent captured the concern bluntly. She wrote that under the majority's reasoning, a president could order the Navy SEALs to assassinate a political rival and claim immunity because commanding the military is a core constitutional power. The majority dismissed this as hyperbolic, but they did not actually explain why it would not follow from their reasoning the logic of absolute immunity for core constitutional acts would seem to cover military orders, regardless of their illegality. Defenders of the ruling argue that it protects presidential independence. Presidents must make difficult decisions rapidly. If they constantly fear prosecution for official acts, they will be paralyzed by legal concerns. Moreover, defenders argue there are other accountability mechanisms: impeachment, electoral consequences, congressional oversight. The criminal law is not the only check on presidential misconduct. This is a legitimate argument. The question is whether non-criminal mechanisms are sufficient. Impeachment requires 2/3 of the Senate, a virtually impossible threshold in polarized times. Electoral consequences only apply to re-election eligible presidents. Congressional oversight has proven toothless when the president simply refuses to comply. The immunity ruling assumes that these mechanisms are sufficient. Critics argue that assumption is dangerously naive. Let me now apply the immunity framework to the specific allegations in the January 6th indictment. This is the analysis Judge Chutkan must conduct. The indictment alleges that Trump pressured Department of Justice officials to declare the election corrupt and to support his efforts to overturn the results. He allegedly discussed replacing the acting attorney general with a loyalist who would take these actions under the Supreme Court's ruling. These interactions appear to have absolute immunity. The president has supervisory authority over the executive branch. Directing the Department of Justice is an official act. The court specifically cited these allegations as likely immune. This portion of the case is probably gone. The indictment alleges that Trump pressured Mike Pence to refuse to certify electoral votes or to send them back to states for reconsideration. This pressure allegedly continued. Even on January 6th itself, the Supreme Court said this requires closer analysis. The president does speak with the vice president in an official capacity. But Pence's role in electoral vote counting is defined by the Constitution and is arguably a legislative function, separate from executive branch operations. Judge Chutkan must determine whether these communications were official acts protected by immunity or unofficial acts that can be prosecuted. This is one of the critical determinations. In the current proceedings, the indictment alleges that Trump and his allies pressured state officials to change vote counts, appoint alternative electors, or refuse to certify results. The infamous phone call with Georgia Secretary of State Brad Raffensperger, where Trump asked him to find 11,780 votes, falls into this category. The Supreme Court suggested these might be unofficial acts. The president has no constitutional authority over state election administration. These communications might be viewed as private political activity, not official presidential conduct. If so, they would not be protected by immunity. The indictment alleges that Trump and his allies organized slates of false electors in states that Biden won. These electors signed certificates falsely claiming Trump had won their states. This scheme involved private lawyers, political operatives, and state party officials. It is difficult to characterize as an official presidential act. It appears to be private political activity organized through unofficial channels. This portion of the case likely survives immunity analysis. The indictment addresses Trump's speech at the January 6th rally and his conduct as the Capitol was attacked. His statements encouraging supporters to march to the Capitol and his delay in calling for them to leave are both at issue. Campaign rallies are generally unofficial acts. The president speaks at them in his capacity as a political candidate, not as president, but Trump was also simultaneously the president with authority over federal law enforcement and the National Guard. Judge Chutkan must untangle which aspects of Trump's January 6th conduct were official and which were unofficial. This is deeply complex factual and legal territory. Now let me explain the specific procedural timeline and deadlines. After the Supreme Court's July 2024 ruling, the case returned to Judge Chutkan. She faced the task of implementing the immunity framework through a fair process that gives both sides opportunity to argue. Judge Chutkan issued scheduling orders setting deadlines for immunity-related briefing. These orders established when each side must file their arguments and when responses are due. The specific dates matter because they determine how quickly the case can proceed. Every deadline that passes moves the case forward. Every extension or delay pushes potential trial further into the future. Jack Smith's team took an unusual approach. They filed a detailed brief laying out their theory of the case as it applies to immunity. This brief, which became public in redacted form, provided extensive factual detail about Trump's alleged conduct. The prosecution's argument is that even after removing the Dodge-related allegations, a substantial case remains. They contend that the fake electors scheme, the pressure on state officials, the unofficial aspects of January 6th are prosecutable. Trump's lawyers filed responsive briefs arguing for broader immunity protections. They contend that virtually all of the alleged conduct was official in nature and that the prosecution cannot proceed. The defense also argued that the process itself is improper, that the court should not be conducting this analysis in public filings that amount to a shadow trial. As of the time of this recording, the briefing process is underway. Judge Chutkan has the arguments from both sides. She will issue a ruling determining which acts survive immunity analysis. That ruling will almost certainly be appealed. The D.C. Circuit will review, and the Supreme Court may grant certiorari again if either side seeks review. Legal experts assess that even an expedited appellate process would take several months. A full appellate cycle, including potential Supreme Court review, could take much longer. The practical effect is that no trial will occur before the 2024 election. The immunity ruling did not just create legal doctrine. It created a timeline that makes pre-election accountability impossible. I need to address directly how the 2024 election affects everything I have described. If Trump loses the 2024 election, the prosecution continues. The immunity determinations proceed through the appellate process. Eventually, a narrowed case, focused on unofficial acts, could go to trial. The timeline would be 2025. At the earliest, more likely 2026 if appellate review is extended, Trump would face trial as a private citizen, with the full weight of the federal justice system behind the prosecution. If Trump wins the 2024 election, the calculus changes completely. Department of Justice policy, based on Office of Legal Counsel memos from 1973 and 2000, holds that a sitting president cannot be indicted or prosecuted. The reasoning is that prosecution would unconstitutionally interfere with the president's ability to fulfill his duties. This policy is not law. It has never been tested in court, but it represents the official position of the executive branch, and a Trump Department of Justice would certainly follow it. More directly, Trump could simply order his attorney general to dismiss the case. The attorney general serves at the president's pleasure. An order to dismiss would likely be followed. Even if the attorney general refused, Trump could fire him and appoint someone who would comply. This was the dynamic that created the Saturday Night Massacre during Watergate, but there is no guarantee the outcome would be the same today. Alternatively, Trump could pardon himself. No president has ever attempted a self-pardon. Its constitutionality is untested. But Trump might attempt it, and the Supreme Court that just granted him broad immunity might well uphold it. The point is this: if Trump wins the election, the January 6th prosecution almost certainly ends, not because the courts rule in his favor, but because the executive branch stops prosecuting. This raises a profound question about the relationship between legal process and political timing. The Supreme Court's immunity ruling was issued in July 2024, more than 8 months after the case was first appealed on immunity grounds. Critics argue the court deliberately delayed to prevent a pre-election trial. Defenders argue the court took the time needed to address novel constitutional questions. Regardless of motivation, the effect is clear. A president who may have committed crimes in attempting to overturn an election will face voters before facing a jury. The public will decide whether he should hold power before the courts decide whether he should be held accountable. Some view this as appropriate. Elections are the primary accountability mechanism in a democracy. Courts should not interfere with electoral choices. Others view it as a failure. The courts exist precisely to enforce accountability when political mechanisms fail. Delaying justice until after an election allows a potential criminal to seek the power that would let him escape justice entirely. I present both views because both are held by serious people with legitimate arguments. The question of how legal accountability should interact with electoral timing does not have an obvious answer. Let me analyze what this moment means beyond the immediate case. Whatever happens to Trump specifically, the immunity ruling permanently expanded presidential power. Future presidents of both parties will operate under a legal regime that largely protects them from criminal accountability for official acts. This changes the calculus of presidential decision-making. A president considering an action of questionable legality now knows that if the action is official, prosecution is unlikely. The deterrent effect of criminal law has been substantially weakened. Some view this as proper. Presidents must act boldly. They should not be paralyzed by fear of prosecution. Others view it as dangerous. Presidential power already exceeds what the founders intended. Further expanding it, especially by removing criminal accountability, invites abuse. The Supreme Court's intervention in the Trump cases has deepened concerns about the court's legitimacy. Critics argue the court is acting as a political ally of the Republican Party, using procedural mechanisms to protect Trump from accountability. The immunity ruling fuels these concerns. The court majority, all Republican appointees, granted broad immunity to a Republican president facing prosecution. They did so using reasoning that many legal scholars find unpersuasive and that 3 dissenting justices called dangerous. Defenders argue the court is simply applying constitutional principles regardless of political implications. The presidency needs protection. The court provided it. Politics played no role. The public will draw its own conclusions. But poll after poll shows declining confidence in the Supreme Court. The immunity ruling may accelerate that decline. Nothing prevents Congress from responding to the immunity ruling legislatively. They could pass laws specifying that certain conduct is unofficial and prosecutable. They could strengthen accountability mechanisms for presidential misconduct. Whether Congress would act is another question. Partisan polarization makes it unlikely that any Congress would constrain a president of the same party, and the immunity ruling itself might be construed to limit congressional power to define presidential conduct as unofficial, but the possibility exists. If the public demands accountability mechanisms and elects representatives committed to providing them, change is possible. The immunity ruling is not the last word. It is an invitation for democratic response. Let me bring this analysis to a close. The Supreme Court's immunity ruling and the deadline-driven process now underway represent one of the most consequential legal developments in American history. The courts are determining in real time how much accountability applies to the most powerful person in the world. Here is what we know with certainty. The immunity framework creates three tiers: absolute immunity for core constitutional powers, presumptive immunity for other official acts, and no immunity for unofficial conduct. Judge Chutkan is conducting the process of applying this framework to the January 6th indictment. Briefing deadlines are set, rulings will follow, appeals are certain. The timeline makes pre-election trial impossible. If Trump wins, the prosecution likely ends. If he loses, a narrowed case proceeds on a delayed schedule. Here is what we do not know: exactly which allegations will survive immunity analysis, how the appellate courts will rule, whether the Supreme Court will intervene again, and ultimately whether Donald Trump will ever face a jury for his conduct surrounding January 6th. These are not questions I can answer. They are not questions anyone can answer with certainty. The legal process is ongoing. The political process is ongoing. The two are intertwined in ways that make prediction impossible. What I can offer is this understanding: the immunity ruling is complex, but it is not incomprehensible. The procedural timeline is intricate, but it follows logical steps. The stakes are enormous, but they can be clearly articulated. My goal with this channel is to provide that understanding, not to tell you what to think, but to give you the information you need to think for yourself. If you found this analysis helpful, subscribe and turn on notifications. I will continue covering the immunity proceedings, the deadlines, and the rulings as they develop. Share this video with anyone who wants to understand the substance behind the headlines. The more citizens who understand what is actually happening, the better our democracy functions. Thank you for watching. I will see you in the next one.